Hello, NABU students. We have been charging through the material in the course. We've done a chapter or topic 1, topic 2, topic 3, which is the Canadian legal system, and that concluded with a discussion of arbitration. One comment before moving on. I included it in the chapter on the Canadian legal system, but it is not just something that is in the Canadian legal system. Arbitration is in the Canadian system, the UK system, the United States system, civil law countries around the world. Quite a few have arbitration systems. Most do, as a matter of fact. Okay, so now we're moving on to the United States legal system, and that is slide 34. Slide 35 is merely a reference to the United States Constitution. They're one document. They do have other what they call quasi-constitutional documents, as does Canada. For example, they have their Declaration of Independence, which they often refer to, and then they have their Civil Rights Act, which is a federal statute. And that allows constitutional challenges to the Supreme Court of the United States. So it's a quasi-constitutional document. In Canada, I didn't mention any quasi-constitutional documents, but obviously in British Columbia, for example, we have the Human Rights Code, which protects the civil liberties, discrimination against race, color, religion, creed, sexual preference, and that sort of thing. It's a quasi-constitutional document because it is in fact a provincial statute and can be amended when necessary. BC has another quasi-constitutional document which is a little strange. During the constitutional debate and the repatriation of our Constitution, Premier Gordon Campbell of the province of British Columbia decided that he wanted to pass a Constitution Act. And so British Columbia has a Constitution Act, but unlike the federal Constitution acts, which have a provision which makes it very difficult to amend, for example, if the federal government wanted to amend the Canadian Constitution Act of 1982, they would actually, there's a number of amending formulas, but one of them says they would actually have to have the federal government's approval, over 50% of the provinces having over 50% of the population, and then a change could be made. The BC Constitution Act, the legislature of BC could change that at any time. But anyway, the Constitution Act in the United States is their founding-based document, and we have heard a great deal of discussion about that in the media, given what's going on in the United States now with President Trump attacking certain aspects of their rule of law and stating on the one hand that he has omnipotent power, he has the power to do anything. Not so in the Constitution, and so it's an ongoing debate there right now, and it'll only be decided with the next upcoming federal election. The setup of their system is set out in slide 37, and there are 4 elements to their branches to their system of government, and they are so proud that they have these checks and balances, but we saw the disastrous results of thinking that is in place all the time. There is the president, okay, and he has certain rights under the Constitution, and then there's the Senate, 2 senators elected from each of the 50 states. Then there's Congress with elections based supposedly on a sort of a population base. And then there's the United States Supreme Court. The difficulty we have they have in the United States right now is they have a rogue president. I was going to say a Republican, but he's really not a Republican. He's just a rogue president. We have a Republican Senate, which for some reason is extremely nervous about doing anything to upset Trump because of Trump's base of support, which they all think that they will need to be reelected to their positions of power. So consequently, they have given up their role as one of the balancing factors in their system, and they just follow along beside or behind Trump, because more Republicans are elected as senators than Democrats. Then we have Congress, and for a while there, Congress was also controlled by the Republican Party. That allowed them to then start stacking courts throughout their country with Republican judges. And now they have, of course, the Supreme Court of the United States with more Republican nominated and approved justices than Democrats, and it is not an unbiased body by any stretch of the imagination. So suddenly there were no checks and balances in the United States, which allowed Trump to run roughshod over their whole system and to challenge the rule of law. Congress in the last midterm elections swept in Democrats, and that started a balancing act. But you could see that quite clearly the Congress of the United States impeached President Trump, and he is impeached, all right? The fact that it went to the Senate and the Senate did not remove him from office does not mean that President Trump has not been impeached. So you have this bizarre situation in the United States where an impeached president is still in a position of power. And boy, I tell you, if you're watching the news, you really have to suspect that this president is not fully compos mentis. Imagine thinking in the midst of the COVID crisis that one of the best ways to defeat this virus is to inject people with disinfectant and Lysol and Purell and things like that. I mean, it's just and he seriously was suggesting this as to, hey, look, everyone, I'm President of the United States and my uncle was a doctor, ergo, I have a solution to the crisis. He did that. It's just unbelievable. Anyway, and people are afraid to confront him for some reason. So anyway, they have the situation where they're supposed to have checks and balances in their system, but there can be situations, which do not happen very often, but happened in this case, where they had no checks and balances at all. The next slide shows the U.S. court system, and it is a federal system like our Confederation system in Canada, where you have two branches of government, or courts. One is the state courts, and the other is the federal court. Okay, and they both appear to suggest that they could make you could appeal to the United States Supreme Court. Not so. If you have a federal matter regarding tri-state transportation, tri-state criminal matter, then you can go up through their appeal system and request that the United States Supreme Court hear your appeal. On the state level, however, you can see that there's one. I'm just going to remove my card, which prevents me from looking at the screen as opposed to looking at the camera. At the state level, it says the state Supreme Courts. So you go from state trial courts to the state of appeal courts, and then to the state Supreme Court. And then there's an arrow that goes up to the Supreme Court of the United States. Well, that doesn't mean that you automatically have that. The only way you can get from the state Supreme Court, which is their highest court, you have to be careful because in Canada, of course, we have the BC Supreme Court, which is just a court of first instant, okay? And then you can appeal to the BC Court of Appeal, and then you can apply for leave to appeal to the Supreme Court of Canada. But their state Supreme Court is their highest appellate court. So if I was dismissed as an employee from your business and I sued you because I thought it was wrongful dismissal, I would start in the state courts, and then I would go to the state court of appeal, and then I could appeal to the state Supreme Court. That would be the final appeal. There would be no appeal that would go on through to the United States Supreme Court, with some very minor exceptions. And one of those is, for example, if I was dismissed as an employee and I was of a minority group, like a black or an Hispanic, and I felt that the reason for the dismissal was not because I was a bad employee, but that because I was a black or a Hispanic, then I could start in the state court. I could appeal to the Court of Appeal in the state, and I could appeal to the Supreme Court in the states, and then I could apply to appeal to the United States Supreme Court. Is their highest court in the land a impartial, unbiased observer of fact? No, it is not. I can say that specifically because there's plenty of proof, and you can see how dogmatic or ignorant presidents can be about it. And I'm not talking about this president. I mean, quite frankly, I think that's a given, but that's only my personal opinion. But George W. Bush, for example, when he was the President of the United States, was talking about appointing a judge to the U.S. Supreme Court, and he wanted it to be a Republican judge. And when he was being interviewed on a news channel, the news channel said, so in other words, the United States Supreme Court is a political body. And he went, oh, no, it's not. No, it's an impartial, unbiased observer of fact. And, no, it's, and then he turned around 2 seconds later and said, if they could just get one more Republican judge appointed to the U.S. Supreme Court, then maybe they could overturn Roe versus Wade. Roe versus Wade was an abortion case, and it allowed women control of their bodies. And the Republicans, because particularly of the Tea Party and the strong church, want abortions made illegal. And so they want to overturn Roe versus Wade, overrule it. As you remember, the 5 things judges could do. They want to overrule that. And so on the one hand, he was saying it was an impartial, unbiased observer of fact, and then he's turning around and he's saying if we can just get one more Republican on the bench, then we can overturn Roe versus Wade. And didn't see any problem with that logic. Ask Al Gore if the United States Supreme Court is biased or not. When Bush and Gore were combating to see who was going to be the president of the United States, it looked as though the difference was going to be whether certain ballots in Florida were either counted or dismissed, because they have a system where it's almost like a lottery. You go and you vote, right? It's not quite that bad, but it's like a slot machine. There's all the names of the people you want to vote or for the presidency. There's 2, and you indicate who you want, and then you go, and you pull this arm, and it goes, and it punches a hole in the card, and then the card is then taken out and counted. Well, some of them got dimpled but not punched. There was no hole, and so those were disqualified. Had those been counted, and the people obviously intended to vote for Gore, then Gore would have won Florida. He would have become president of the United States. The matter was referred to the United States Supreme Court as to whether these dimpled cards should count or not. And the United States Supreme Court said, no, they should not. Bingo. Well, let's put it this way. The 5 Republican judges on the Supreme Court voted for George W. Bush. The 4 Democrats voted for Al Gore. And bingo, Bush becomes president, not because he was a clear winner, but because the stacked U.S. Supreme Court voted for him. Okay, so that's the court system in the United States. The United States is a common law jurisdiction, but they have been over the last, I don't know how many years, 10, 15 years, moving towards unifying their laws, right? So we have this Universal Commercial Code, which is on slide 39. And so they're trying to codify all their laws, which sounds a lot like a civil law jurisdiction. I think if a section in their code was unclear, you would still have jurisprudence, case law being used to argue whether, what it meant or not. But they're trying to codify it to get some sort of consistency across the 50 states. And in my article, The Convergence of the Legal Systems of the World, I do talk about this because it shows that the codes in civil law jurisdictions provide consistency and predictability to a greater degree than case law. And so the United States is saying, let's use some of their best practices. Let's codify for consistency across our country. And so they're using one of the best practices of the civil law system. They've had all sorts of problems. For example, in the United States, they have no universal criminal code. There is no way they're probably going to get to that. And there's real differences. In the state of Texas, if someone breaks into your house, you can take a gun and shoot them with impunity. Okay? Your land is your land, and you can protect it with a gun. So you can shoot that person, kill that person, and there will be no legal consequences. The person runs out of your house and they're running down the street, and you take out your scoped rifle and you go, got him. That's murder because he's off your property now. Okay, so the states, Texas has a right to use, force to protect their property. Try that in Massachusetts. Massachusetts, you'll wind up going to jail for, murder, and then it'll be probably, reduced to manslaughter depending upon the circumstances or something. But very different laws, 50 criminal codes plus a federal criminal code. The federal criminal code applies only in situations where the crime committed involves 3 or more states. Okay. But they're moving towards trying to unify their laws. So, marriage laws, no luck at all. Torts, no luck at all. What else you got? Family law, no luck at all. Estates and wills, no luck at all. Commercial practices. In my article, I say that commerce has been the driving force to try to bring all the laws of the various countries together. We saw that with Lex Mercatoria, okay, a commercial law that developed like the common law in England, but it developed not only in England, but on continental United States. Well, actually, we haven't seen that yet, but we will. Okay, that's in the international law chapter, but we'll see that. All right, but they have a universal commercial code. So the commercial laws of the United States have been unified in this document. The states adopt it, and now it's being used to settle disputes. Okay, that ends our very brief discussion of U.S. law. Mexican law is even going to be a little briefer because I know more about the U.S. law than I do about the Mexican law. All right, Mexican Civil Code. Stare decisis, no. One decision of the court may serve as precedent to bind judges in subsequent cases, as long as they're based on the same legal principle. Okay, that's the United States, that's the United Kingdom, that's Australia, that's New Zealand, that's Canada, excluding Quebec. So stare decisis is the common law system. They do not have that in the Mexican system. It is a civil law system. They refer only to the code, supposedly. They have something called jurisprudencia. And when I was writing that article, I had an opportunity to talk to a lawyer, senior lawyer with Guadalajara law firm, and talked to some of the partners there. And I also talked to a state court judge in Jalisco. And they all said that they do not discuss precedent, and yet they have this thing called jurisprudencia, a series of identical decisions, 5, on a legal principle will be considered as binding law. So you have this particular problem, you look at, this is the article, and you go in and you say, the outcome is automatic because here are 5 cases which all found that this should be applied this way. Sounds like precedent. But when I asked the judge if that was precedent, he said, no, it's not precedence, it's jurisprudencia. So then I went one step further and I said, okay, let's say I have a dispute of an article in your civil code and I have 3 cases that have been found in favor of applying it one way. Can I use those 3 cases to get the result that I want in my dispute? Oh, yes, because that's leading to jurisprudencia. And I said, but that sounds like precedent. No. And there's another term for it, and I'll dig around and find it. I thought it was in my article. I took a quick look at it. It's academic something or other, which means that this is an academic argument, not a legal argument that this article should be applied that way. So you have a smaller number of identical decisions on a legal principle will allow the lawyer to argue case law, but it's not considered to be jurisprudencia. All right, Mexico has a constitution, a constitutional document which was brought into effect when they managed to get rid of the Spaniards. Their court system, again, it's a federal judicial type court system, and you're not going to be tested on it, but they have the Supreme Court of Justice of the nation, and then they have the district courts for their various states, and they have the federal court all leading up to that. Is there Supreme Court of the United States or of Mexico an impartial, unbiased observer of fact? Quite frankly, I don't know. It's really not that pertinent to our discussion. So that's all we're going to say about the Mexican system, except in the article I also mentioned that the Mexican judicial system has been experimenting with the concept that maybe you should be considered innocent until proven guilty. And so in some of the northern states, very close to the U.S.-Mexican border, there was a trial, not a trial as in a trial in a court, but a sort of a trial system of trying to find out whether that might work better and provide better justice. So those courts are taking the position that you are innocent until proven guilty. The rest of the country, you're guilty until proven innocent. All right, so that finishes off the Mexican legal system. And now we're going to get into the international law. And we have to be a little careful here because we're talking about the international law as it applies to North America as opposed to the international law that applies to the whole world. And just going to take a short break here.